Ma'am, we can start.
Hi, good evening, good afternoon rather. Uh, so this is me, Shahrukh, and Gautam and Farah together. We've got together to discuss the discourse around both the hijab controversy and the judgment of the Karnataka High Court. And if I could just start with one question that's been bothering me, and then invite Gautam and Farah to sort of comment on it. It's about the framing of the issue itself. How do we frame the problem? And to my mind, any executive action should have a cogent ground, even if it's not restrictive of any fundamental rights or any rights. If you're doing something, if the state is doing something, there has to be a reason for it. And to my mind, in this instance, the cogent grounds, the reasons for that government order, that circular that proscribes certain pieces of clothing has not been gone into at all or has not been gone into sufficiently. So there is no explicit uh, presentation of the cogent ground behind that circular. I've been asking myself, I've been thinking of other examples, and I've been thinking to myself, what if the local RWA, for instance, or my collector were to come out with a circular that said that all people in the district are to wear military fatigues between 7 a.m. and 7 p.m. And this is in the service of the nation. This is in order to instill feelings of national unity and national integrity and security. And we should all be in readiness for war at all times. Mustad Jung. And if I were to go to court with it, if I were to say that, you know, being in readiness for war at all times, is that even a legitimate aim? A. And B, me wearing military fatigues or everyone else wearing military fatigues, does that aid that particular cogent ground, being in readiness for war? Is there a rational nexus? In this instance, I also must say that I don't think this particular inquiry would go very far because the state would come in and say that national security is primary and we can only decide on national security. And it would also probably give something in a sealed envelope to the court, and that would be the end of that matter. But still, the court will have to look into whether wearing military fatigue aids national security, whether it aids national unity and national integrity. And if it doesn't, what else does? What else contributes to these values that we must instill? Rather than doing that, in this particular case, the court is asking me why I'm insisting on wearing denims and white shirts, for instance. Why can't I just wear military fatigues? The court is saying to me that, look, wearing denims and wearing a white shirt is not part of your religion. It's not part of your culture. It's not even part of your history. You haven't been doing that since ancient times. So, what is the problem? Why are you not wearing it? It's a reasonable restriction. So, rather than inquiring into whether the cogent grounds are good enough, whether there's a rational nexus, whether there's proportionality, the whole debate has shifted to why I can't just agree to wearing military fatigues and not insist on wearing denims and a white shirt, for instance. That's one part of it. The other part of it is, even if everyone were to wear military fatigues, what else would be accommodated with it? Can I wear a cap which has a pictorial depiction of Shivaji Maharaj, for instance? Would that be acceptable together with the military fatigue? Or could I wear a cap with an angry Hanuman logo on top? Would that be acceptable together with the military fatigue? If I'm newly married, could I be wearing red chudas with my military fatigue? Would that be acceptable? Could I be wearing a hijab with my military fatigue? Would that be acceptable? Could I be carrying a green flag with a crescent moon on it? Would that be acceptable? So the second question is about, even if you're insisting on a particular uniform in particular spaces and particular times, what do you accommodate and what do you not accommodate with it? And in this case, that inquiry has again not been done to my mind. May I first invite Farah and then Gautam to sort of build on this?
Yeah, thank you so much, Shahrukh. So I completely agree with you. The starting point for me is when you have state action, or when you have action that a state-funded body, including an educational institution, has undertaken. The first question really should be, by what authority have they done this, right? By what authority have they made this decision? By what authority are they doing this act? And that strangely was really not the question that the court focused on. I mean, I say strangely, but I think this is actually very common because of the real overrepresentation, the real overemphasis on constitutional law issues compared to administrative law issues. Because I think administrative law focuses your mind on exactly that question that you asked, Shahrukh. By what authority is this state acting? By what authority is this public body acting? And in this particular case, I think the only way to understand by whether the state, whether the educational institutions, whether the colleges actually have authority to do what they're doing, by, in your example, the mandating of the military fatigues, in this particular case, the prohibition of the hijab. The only way we'll understand that really is to look very closely at the empowering legislation, the Karnataka Education Act. But again, what's in a way, I think problematic, but again not unusual, is that whole inquiry gets very, very little attention. And I think that if the focus, if the framing had been on that particular inquiry, the result might have had to be different. Because what is the government saying, and what are the colleges saying when you ask them, okay, by what authority are you undertaking these actions? Well, they're saying, okay, well, the government issued this government order, and that government order we had authority to issue under the Karnataka Education Act, right? But if you look closely at the Karnataka Education Act, again, not something that the court, in my view, did at all, you get a really clear sense of what the purposes of that act are, right? If you read it closely, you read it contextually, you have in the act these references to the composite culture of India. You have these exceptions made for children and parents of children who don't want to go to class where there is religious education. There is actually a prohibition not just on religious discrimination, but on any speech which amounts to which wounds religious feeling, which amounts to religious propaganda that wounds religious feeling. So I mean, it goes even further than just generally saying there shouldn't be discrimination, right? So when I look at this act, it's, to my mind, very clearly an act that has as amongst its purpose the promotion of inclusive, sensitive, tolerant education, and education that's also focused on the needs of the more vulnerable members of society. I mean, there's a section of the act that actually says that the government is obliged to pay particular attention and promote the education of weaker sections of society, which the students who are affected by this government action probably would fall in that group, right? So you have these purposes set out under the act, and we have administrative law rules that say that any government action has to be in conformity, in furtherance, in fact, of these kinds of purposes. And the power to issue directions that the government is claiming to have under the act is only insofar as those directions conform with further the purposes of the act, right? So if the court had framed the issue as you're suggesting, Shahrukh, of asking that fundamental question before we're getting into the question of, have we infringed someone's rights? Is that infringement justified. If we start with that initial question of, here's the government doing something, here's a state body, here's a public body doing something, by what authority are they acting? I think the result may have been different if that had been the focus. And I think that's, I mean, administrative law is not considered the most, certainly not the most fashionable, and for some people, not the most exciting area of law. But I mean, I'll tell you why I think it's so important in this kind of a case. It's because if you think about it, these students, they're showing up to their education institution, they want to study, they're being barred at the gates and so on. And someone's saying you can't do that. I think they're entitled, and all of us are entitled to clarity about why they can't enter the school wearing what they want and so on, right? So that clarity, which to me is what the rule of law is all about, is exactly why we should care about these administrative law principles, these principles that require you to focus on the question of legal authority for state action. Gautam, did you want to
Therefore,
reflect?
when
Yeah,
you
sorry.
say, Farah, a lack of authority, you
Mhm.
mean you mean jurisdiction, you also mean procedural propriety, and then you also mean lack of arbitrariness, right? So there has to be jurisdiction. They have to have the power to do it. They must have followed procedures, and there must be a cogent ground in law. Is-
Yeah, absolutely. Yeah. So they have to, I mean, their action, in my view, is ultra vires the act. So they didn't have the power to do it. And, the basic, apart from that, the basic administrative law principle that states that any government action, any state action has to be done with a proper purpose. Their purpose was not proper, and it was arbitrary. And as you say, as you suggest, there's that question of arbitrariness as well did not receive much attention in the court. But I think maybe we can talk about that a little more as we get deeper into the discussion.
Yeah, I mean, I think that just to take on from there, I think one of the, at least when you read the judgment, what it comes out from it is, and again, this goes to the issue of framing, that the second question that the court frames is that, is there a power to prescribe a uniform? And I think that the analysis that follows, and this includes the questions that you have highlighted about, jurisdiction, cogent ground, all of the administrative law points, that get subsumed in this overarching question of, is there a power to frame to prescribe a uniform? And even when the court analyzes the administrative law part of the of the case, it's in the context of, does the act authorize or allow for prescribing a uniform? And I think that actually is a good example of how the framing of the question then determines the answer. And if you frame the question differently, you may have reached a different answer, because, of course, the argument was never that there is no power to prescribe a uniform. I mean, there are arguments in outside of law that are against uniforms in general, but at least as a legal argument, it's nobody's case that the government, or, I mean, there were some challenges to the CDC's composition, but apart from that, cannot prescribe a uniform. The argument was that there are things that you can wear in accompanying a uniform or along with a uniform, that fall well within the scope of what reasonable accommodation entails, and the prescribing of that, the denial of any kind of reasonable accommodation within the context of a uniform, is what is the arbitrary state action, or is what is the legal action there, which in I think was dealt with in a somewhat circular manner by the court, because when the court refers to the concept of reasonable accommodation, it says that in this case, the wearing of the hijab does not fall within the scope of reasonable accommodation, because that would undermine the uniformity of the uniform, which is circular, because the whole point of reasonable accommodation as a doctrine is exactly that there exists a default, and there is an understanding that the default is and this is true for any society, the default is always in a certain way insufficiently attentive to the needs, to the cultural expression and so on of certain sets of people in society. And so reasonable accommodation basically says that yes, it is inevitable that the default will conform to certain norms, because that is, that follows from, the fact that we live in a society where there is a majority and there are minorities. And having established the default, you then also accommodate certain deviations from it. And of course, what you accommodate is then determined on a case to case basis. So I think that the quote, in a certain sense, the reasoning is a bit circular, because the whole point of reasonable accommodation is that yes, there is a uniform, and yes, within, the uniform, you have scope for a certain amount of accommodation. And I think that also it's interesting, because a little later on in the judgment, I think this is something also worth thinking about a little bit. The court actually does show that it's actually capable of drawing these discriminations in degree, because when it comes to the discussion of a South African case involving the nose stud, the court distinguishes the two cases, saying that a nose stud is ocularly insignificant and the hijab is ocularly significant, I guess, and that therefore the nose stud does not disrupt the the broader goals of the uniform, whereas the hijab does. And I think there's something to be kind of said for the merits of the argument on its own terms as well. I don't think it holds up, but it also shows that actually, I mean, the court actually is and can draw these distinctions, can actually, is able to analyze these issues in this context. And that's why it's a little surprising that it doesn't do it throughout the judgment. So I think that's something to think about. And I guess, like, just going back to the initial point that Shahrukh made, and I think I'll perhaps ask you a bit about this. Is so one thing you said was that, it's also, it has to do also with when you're asking about what the cogent ground is and what the base of the state action is. Part of it has to also do with whatever values or norms that it's seeking to enforce. I think that one subtext that comes through in this judgment, I think it comes through specifically a little towards the very end, when the court cites an Ambedkar line from the States and Minorities book, is that, and the court doesn't really go into it in too much detail, but it seems to be an animating feature throughout. Is that actually banning of something like a hijab or any kind of head covering is actually, I mean, the cogent ground seems to be promotion, not just uniformity, because I mean, I think the major text for the judgment is that uniformity is kind of like, the core principle, but also in some way promotes equality, which I think sets up this kind of tension between the claims that the state is through this ban is, basically compelling people to be equal, and in a certain sense, taking away, say, markers of inequality that the headscarf is, vis-a-vis, the argument actually made, which is that, well, if when you force something, um, or ban it, or compel something, then by definition, then you're not actually promoting equality, because you're taking away choice. I thought that perhaps I'd ask you. So the court really tries to avoid this whole very, very messy debate around contextualized choice, to what extent it's a choice, to what extent it's not. But it really can't help it creeping in at various points, right? So I was thinking, what do you
Yeah.
think about that whole debate, and how it kind of intersects with this case here?
Yeah, thank you for that. I've been thinking about that, Gautam, and I think Farah might like to step in also. But I've actually looked very carefully at whatever broad cogent grounds the state provides to the court, and that's at page 30. And they say that, of course, they say that we're trying to cultivate a scientific and secular outlook, but they also say that this is in order to instill freedom and dignity. So, wearing of the hijab is violative of freedom and dignity, also harmony and common brotherhood, And then they explicitly say that this is important because wearing of the hijab is derogatory to the dignity of women. And then they reference the role that individual choices of women should play in the construction of women's agency. So all of this has been submitted by the state. And like you say, the court hasn't really dealt with it. The court has completely avoided it. Now, my initial feeling is that it may be a question of choice or lack of choice, but there's no discussion around it. There is no objective data, there's no ethnographic study, there's nothing at all. So what has been given to the court is that this is violative of freedom and dignity and of agency of women, and the court seems to have endorsed that view without any kind of inquiry. But what is also instructive is the two instances where during the oral hearing, the court draws an example. In the first instance, the court says that, what is this whole thing about not being able to ban the hijab just because it explicitly doesn't say so anywhere? Have we also not banned firearms? So the court very explicitly draws a comparison between wearing of the hijab and bringing weapons, bringing a firearm to school, indicating that it's an obvious, it's a given that you can't do this, whether it's written in the rules or not. That to me was very instructive, and I'll say why. And in the second example, the court draws a comparison with ugliness, wearing of the hijab, and being ugly. The court says that if a girl who's not Muslim wants to wear a covering just to sort of hide her ugliness from some skin disease, we will still not allow her, and that is why this is the wearing of the hijab is not discriminatory to Muslim women alone. But the comparison with ugliness and the comparison with violence are both very instructive because it also shows how the court is viewing the hijab. So, without even going into any inquiry, without even going into any objective or subjective inquiry, the subtext seems to be that this is something that is not good. This is something that comes from radicalization. This is something that comes through doctrinization of women. And this is something that is extreme. This is something that is uh, that violates individual choice. So to answer your question, Gautam, there is no explicit discussion, but there is a lot of subtext to work with. And I think we should pick it up and discuss it because it's reflective of what the court is thinking.
Yeah, I just want to, I think maybe I'll ask for about this as well, but I just want to, before that, I think maybe lead on just very shortly. It was interesting for me because when I was reading the judgment, I came across a quote from the UK House of Lords judgment, this Denbigh
Yeah.
case, and the court cited that judgment, that paragraph in support of its argument that that the importance of uniforms, not simply for uniformity, but for egalitarian values.
Yeah.
And the passage just surprised me a little bit because I think when you read a lot of judgments from a jurisdiction, you kind of have an intuitive sense of when something is just feels a little bit off.
Hmm.
So I just went and I read the actual case, and what's really surprising was that the court cites paragraph 97 of this judgment, and it's some Lady Hale, which is even more. When I
Hmm.
saw it, I was even more surprised. And then in the very next paragraph, which is paragraph 98, Lady Hale has this kind of extensive quotation that actually deals with exactly these issues, which is contextual choice and
Hmm.
how it is you're always negotiating this idea of choice. And the whole case actually is a case where there was this school where, in consultation with the local community, the school allowed deviations from the uniform to the extent that they allowed salwar kameez and they allowed the hijab. So that was kind of the baselines. That was a reasonable accommodation. And after that, there was then subsequently a further demand to wear the jilbab, which then was
Hmm.
denied by the school. And
Hmm.
then the court finds basically that that the reasonable accommodation had already happened with
Hmm.
respect to the hijab. And that was kind of like, for the court, that you can go so far, but further than that, it's up to the school to really decide at what point does the deviation from the uniform actually become impermissible. And the whole discussion there actually is about, at what extent, at what point do you say that the public, say, values of equality, of freedom and so on, become so overriding that they then allow you to actually negate the demands that come, or the claims that come, also based on rights. So that, I think, was interesting. But I thought, just to kind of contextualize that, and
Yeah,
perhaps
yeah.
go to Farah.
No, I agree with you, and I want to say that that judgment is also has come out in a context where in the UK there is a debate, there is a discourse on public spending on education and on health. There is also a larger discourse around education. So in our context, where there's no discussion on public education, on public spending, on democratic spaces within public education, participation of stakeholders within educational spaces, how do we look at uniforms, where uniforms are completely centralized and unilateral and statist? Stakeholders have no say in it, apparently. So this could have been an entry point, even if we were to talk about uniforms and equality and egalitarianism. This could have been an entry point for that larger debate, to talk about fraternal dining in schools, to talk about midday meals, what gets served, what doesn't get served, the inclination towards vegetarianism in school. All of that could have been talked about, but we're only talking about a certain opaque kind of discipline, which is sort of handed down. And it's particularly ironical. It's particularly self conscious on the part of the court, I feel, because the reason for it is that the hijab is the controlling kind of garment. The hijab indicates lack of choice. So, therefore, the state will ban it, or the school will ban it, and replace it by a mandatory uniform without any kind of discussion, without any kind of space to stakeholders to say what they feel. So it's quite contraindicative in that sense also, Gautam, I think. And just to add to that one last point, we're talking about freedom and dignity. How will these schools, for instance, accommodate trans rights who want to wear genderless clothing to school? Uh, if it's going to be so unilateral, if it's going to be so centralized, if we're not first talking about accommodating pluralities, what will we do with other communities and other self-expressions and other self-interests that are now coming up and also being endorsed by constitutional courts?
So, if I can comment on some of the really, I think, interesting and insightful points you've both made. So, I think, Shahrukh, the point you just made is, I absolutely agree with it. It's, to me, very puzzling for anyone really to say, okay, wearing a hijab or wearing a headscarf is inconsistent with your freedom because you must be coerced into doing it. This must not have been a free choice, and we're going to make you wear this uniform, right? So in the context where everybody in that institution is being given no freedom to wear what they want, despite probably having deep preferences, maybe principled preferences about what they might wear. Maybe certain people care about ethically sourced garments. People might have preferences about color and so on. So if we care about choice, why do you have this general rule, right? Now, it's important to re-emphasize the point that Gautam made, which is that nobody, as a legal matter, challenged the lawfulness of a uniform policy. But it should be said that there is, to my mind, something kind of absurd about complaining about or assuming and complaining about a lack of choice with respect to hijab in a uniform context. So I think that's a really important point that you made, Shahrukh, and I just wanted to underscore it. And I guess the other point that came from Gautam that I think is really helpful is, Gautam, I think you absolutely characterize the issue correctly, when you talk about the majoritarian norms as the default, because when you and I think that's exactly the way to understand that discussion of the nose stud case, right? So why did they think the nose stud was quote unquote ocularly insignificant? They thought it was ocularly insignificant. I mean, it's a strange term. They, for them it was nothing to remark upon. It's normal, because for them that is a majority, that's a majority practice, right? So it's something that they see as a part of majority practice and therefore normal. Whereas what is seen as abnormal, what is seen as deviant, what is seen as ostentatious or standing out, those are really minority practices, practices that they don't personally identify with themselves, or they don't see as a part of their own practice, right? So so if we were to take that their approach to uniforms and what is acceptable as a part of a uniform, what amounts to accommodation that the state has to do with respect to a uniform, if they take that approach, it basically means that all majority practices are normalized and are accepted, and all minority practices are abnormalized and are not protected, right? And that, of course, is the absolute opposite, in my view, of what a constitution should do, right? And what a constitutional court should do. Because really, it's the deviant, the quote unquote deviant practices, the unusual practices, the practices that are considered bizarre or strange and so on, that I think a constitutional court should be particularly attentive to, not the other way around. So I thought those were both really, really important points that I just wanted to comment on. And just to go back as well to this concern with choice and this concern with freedom. The other feature of the judgment that I find interesting is, and also the government rhetoric, is, so there's this assumption that these students are not free while they are wearing a headscarf, and that if they wear a headscarf and do that and seek education while they're wearing that, they are somehow less free than they otherwise would have been. Well, around the world, societies have thought about accommodation and questions of multiculturalism, and the liberal response to these kinds of worries in multicultural contexts is that you ought to give people in these situations a right to exit, right? A right to exit from the communities that you are worried are oppressing them, that you are worried are forcing them to do certain things. Okay, how do you get a right of exit? The quickest and easiest and absolutely necessary thing to get a right, to have a right of exit in contemporary societies, is an education, right? So really what you should be doing is facilitating education. If you really thought, and I think we all wisely will have doubts about this, but if you really thought, okay, these students are oppressed, they're not free, and so on, what you should be doing is thinking, okay, I'm going to make sure, come what may, they get a fantastic education. I'm going to give them that right to exit, so that if they're in a bad situation, they can leave. Now I'm skeptical about those premises, but if you accept those premises, I don't think this is the right government response in any case. I don't know if any of you wanted to comment more on any of that, but Gautam, I was just interested as well. You talked a little bit about equality and non-discrimination jurisprudence. I wonder if you had any other views on how that jurisprudence has developed and how that might have affected the case. And I'm quite interested as well in the fact that when they talked about discrimination, they talked about discrimination and arbitrariness in one breath, right? So the arbitrariness argument was basically conflated with the discrimination argument, which I think was a huge mistake. I'm interested in talking in sort of thinking about the arbitrariness argument, but I was curious to hear both your views on discrimination and equality jurisprudence with respect
Yeah, I
to
think
this
it
issue as
also
well.
really follows from, in fact, what you said about the default, and the exception to the default, and what seems to be ocularly significant and insignificant. I think the equality argument really stems from there, and it's interesting because and I was thinking that if you look at the entire set of debates around the crucifix cases in Europe, right? All these cases where there was debates over whether you can have the crucifix on the wall of a classroom. And then you have the South African debates as well, the North Star and other such cases. In Kenya, you have the dreadlocks debate, right? And when you see the scholarship around those cases, and specifically the crucifix cases, right? The whole the when the ECHR and those courts say that, okay, certain kinds of religious symbols are allowed because they're not actually that ostentatious, or that they don't really invade your
Offensive.
eyesight in that way. The entire critique around that has been that actually this is a very Christian Protestant understanding of religion, where religion is this very private relationship between the individual and God, and it completely negates cultures that in Europe are minority cultures, where the relationship between the individual and God is more outward, it's not inward. And in that way, this actually constitutes indirect discrimination, even though it is facially neutral. And so I think at one level it's interesting that how closely the court's judgment tracks the crucifix cases in the ECHR, despite the fact that this concept of secularism that we have is actually much more accommodating than the strict separation that is there in those European cases. But I think that. So I think that's one point. The second point, I think that this discussion actually in the judgment actually I think shows a couple of things. I think one is that so there's been a lot of criticism that I've seen around the decision, the strategic decision that the Petitioners' Council made to lead with the essential religious practices test, right? And I think that when you look at the discussion in the judgment, you see why that choice was made, hard though the choice was. And that's because whereas over the years the ERP test is established, it exists, and everyone knows what it's about, so like what ground you're on. I think the judgment actually shows that we still have a very long way to go as a jurisdiction, and as jurisdiction with a constitutional doctrine that grapples with discrimination and equality in its full complexity. And I think that this is because of the fact that we don't yet have, those landmark cases that really establish what you call constitutional common sense, right? So we do have in India judgments like Colonel Natisha in the Supreme Court and a couple of High Court judgments about pregnancy that do actually spell out the idea of indirect discrimination, which is that your law or your rule might be facially neutral. It might not be discriminatory on its face, on its own terms, but if its effect is to actually discriminate, if its effect is to single out a group or a set of people and subject them to disadvantage, then it is still discriminatory. It's just you have to look a little harder. You have to look at context, look at history, look at a range of other things. And so while we do have judgments that have done that, the discussion's either been muted or it's been kind of like it goes a little way, it doesn't really go the whole way, and we don't really yet have like we have for privacy, we have like Puttaswamy, right? So there is a case in everyone's head. This is the privacy case. In Maneka Gandhi, there is a case that is the due process case. Vishakha is like there is a case that is a sexual harassment case. You can debate those cases themselves, but you have that common sense that's been established. I don't think we yet have that for indirect discrimination. I think we need that to happen so that there can be a framework or a context within which then the arguments can take place, and then people can actually like take these kinds of cases to court and actually rest them on indirect discrimination, intersectional discrimination, that look, the people you are harming here are not just Muslims, not just women, but Muslim women who are like at the intersections of like gender and religion, right? So that requires a special kind of judicial scrutiny for those kinds of rules. So I think that all of that still needs to be established in our jurisprudence firmly. And I think I think one thing that you see, I think, across the world is that really high pressure, fraught kinds of cases are the wrong kinds of cases. You can actually establish like those principles. You actually, ironically, need somewhat more innocuous kinds of cases, where like the arguments are kind of perhaps more obvious, more intuitive. It's a bit like when Ruth Bader Ginsburg was a counsel. She established gender discrimination as in US law by first taking the case of men to the Supreme Court, and that's how they established the doctrine of gender
Mm.
discrimination in the US Supreme Court. So I think you perhaps need a somewhat more innocuous case that will really establish the principles, which can then really kickstart a jurisprudence in our courts that kind of engages with these issues on a more complex level. I think that this case is interesting in that you see the limits of indirect discrimination in our
Mm. Mm.
jurisprudence that are presently kind of like just constraining us with respect to what arguments that we can make that are not taken as off the wall, in our courts.
So if I can just comment on,
Mm.
sorry, Shahrukh,
No, no, no,
please
no,
go ahead.
Farah, please,
Yeah,
please go ahead.
thank you,
Please go ahead.
thank you.
Yeah.
So so Gautam, I think that's really informative. And I think a lot of people are starting from the assumption, and maybe for good reason, that you'd have to make out a case of indirect discrimination. But some of our academic colleagues, in a brief that will, if it hasn't already, will be soon published on Live Law, are arguing that actually this is a case of direct discrimination, direct on intersectional grounds, but direct discrimination. And to my mind, at least, there is some merit to that argument, because if you take the geo and the language in the geo, it's to I think to
It's
any
very
contextual.
specific.
Yes, right. So it's read contextually, as I mean, if you're interested, if you're trying to ascertain whether something is direct discrimination, you have to read something contextually as well. Then it is aimed at, it's not facially neutral, it is aimed at either, some might argue, Muslim women, or people who women or people more generally who wear head coverings for religious reasons, right? Because it does talk about people practicing their religion, and it does talk about headscarves and so on. So I think there is at least a good argument to be made that, regardless of the difficulties that you've talked about in establishing indirect discrimination, there might be a good argument to say that this was direct discrimination.
I want to come in here for a moment, and it's a clarification really from both of you. Gautam, you did say that nobody argued on the powers or the jurisdiction of the institution of the or the campus development committee to come out with proscription of uniforms. But to my understanding, what had happened was that in the first instance, when the women went to college and when they were first stopped, there were no rules, there were no written orders at all. They were stopped randomly on the basis of oral orders and very localized orders. Then, as the thing escalated, they came out with the GO of 5th February, where for the first time and retrospectively, the campus development committees were given the power to prescribe uniforms. And where there were no uniforms prescribed, they were given the powers to interpret what is what goes with equality and unity and what does not. So it was done retrospectively, and this was questioned, in fact, in court, I think. And what was also questioned was that whether under that act, which gives them general powers to instill secular to scientific temper and secularism, etc., could this be a part of those general powers or not? The power to prescribe uniforms, and then also the power to ban certain things or not accommodate certain things as part of the uniform. So that's one part of it.
Sorry, I just want to clarify. No,
Yeah.
yeah, that was definitely argued. So if I said it wasn't argued, it was a mistake from me. That was
No,
definitely
so
argued.
the
It was just
jurisdiction thing, yeah, yeah. The second point that I want to make is that I think in that example that I gave in the beginning, where if you are to wear military fatigues, would your historical logical mind accept a sticker of the angry Hanuman more easily than a sticker of a green flag with a crescent moon on it? That, to my mind, could be an example of indirect discrimination. That you think that if you're fighting with one symbol, then you're fighting for India. If you're fighting with another, you may or may not be fighting for India. But in this case, where the geo is very specifically proscribing a particular garment, it is direct discrimination. It's not saying anything about any other piece of clothing or any other symbol that can be related to any particular religious identity. It's only about hijab, right? It's not even it's not stopping turbaned men or turbaned women even, except for one incident, and that was later clarified.
So I mean, I'm just to, just to comment on that. So I'm not entirely sure if at least in formal terms,
Mm.
if that's the only reading, because at least in what the court says that, and I think there's one line where the court says that it says hijab not allowed, bhagwa scarves not allowed. So it says a bunch of things,
So,
right?
so let me
Um,
add. So, my question to you is that actually, my
yeah.
question to you is that, so one other cogent ground that the state gave was the fact that nobody has submitted before the court for how long these particular women have been wearing the hijab, and the state is saying that it is a new thing, it is a new practice, and it is happening because there has been a process of politicization. So they are insinuating that there are political groups that are brainwashing the women into wearing them, and therefore they deserve to be proscribed. Now, the court picks up on this, and in the interim relief, when interim relief was refused by the court draws an equivalence, which to my mind is a completely false equivalence, between the hijabis and the hecklers. So they say that if you're a heckler, if you have a problem with hijabi students, and if you're coming to campus with saffron flags or tridents, then that is equivalent to this to these women who have started to wear the hijab in the recent past. So that was my question to you, whether you can equate the banning of saffron flags, which were only being done to protest the wearing of the hijabs, with the actual wearing of the hijab.
I think that there are two issues here. I think one is that, so and this really unfortunately I think takes us back to the ERP test, because if you remember the Acharya Avduta case, right? The two cases, um, that where there was dancing the tandav in the streets, right? The entire reasoning in those two cases is that this is a relatively recent practice.
Mm,
And by recent, I think the recent there was 30 years, 40 years. So that was recent, and because it's a relatively recent practice, therefore it's not essential to the religion. And then what happens is that the founder of that sect, they go back and they basically write the founding texts of the sect, where they specifically put in that this is
mm,
essential, and the case comes back to court, and the court says, "Well, you just wrote this book, so clearly it's not essential." And I think that I mean, I find those two cases, really hard to wrap my head around. But it really shows you once you're caught in the trap of the ERP test, um, automatically it follows that if something is more
mm,
recent, then it's not essential. It has to be immutable. It has to, like, yeah, I guess in the case of Islam, go back to the 7th century, right? This is why the Quran becomes so important in this case. What does the Quran say about the headscarf? And I think that of course the problem with that is that it completely fails to take into account that identity is always in flux, and
yeah,
identity is always
yeah.
in response to external stimuli, right? So in many cases, your own sense of identity, like, develops in response to what's happening around you. And if you say that a belief is not genuine, or a conviction is not genuine because it's recent, then that's basically, I think, the trap of the ERP test. And the moment the case went into the ERP territory, it was always going to be this was always going to be an issue, with respect to the fact that how long have they been wearing the hijab. A second point in equivalence. So I think, no, I mean, I think the issue is not so much um, the equivalence, but I think obviously the interim order, I think, in my view, kind of makes that mistake where it draws that equivalence. But I think, again, if you're analyzing this from the perspective of whether it's direct or indirect discrimination, then for me it falls in the indirect category, because, again, what you are, if your stated justification as the
Mm,
government, right,
mm.
is hijab out, saffron scarves out, X or Y out, and the kind of overarching framing is that visible headgear is out in general. Then I think
No,
that the
Gautam. No, the reason here in this particular case was that these are both causing public disorder.
yeah.
So 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 again, on that ground, it cannot be direct and indirect because one is the heckler and one is not. So if your ground for banning both in this particular incident was that it's causing public disorder, then can you say that both are indirect discrimination?
Um, I mean, I think that, well, so sorry, maybe if I want to comment on that, I'll just like maybe come back a little later after you had this.
Well, can I pick up on the importance of time and when these practices evolved and so on, because I think that is it shows the limitation of the ERP test, as Gautam said, and a colleague of mine, John Sebastian, pointed out in this judgment, you just can't win either way, actually, right? Because if it was a recent practice, then it can't be an essential practice, right? But then if you look at the reasoning for why it can't be an essential practice, they actually accept that this was a practice that it was practiced in Islamic times, and it was practiced in that, it has that element of historical authenticity, but it's not actually protected, or we don't need to protect it because it was a product of a certain socio cultural context, and that context does not exist anymore. So that was a product of a context in which women were not secure and they lacked security, and somehow we're saying that now women have a lot of security. So if it's new, it's not essential for that reason and can't be protected. If it's old, then it's a product of that time, and we can reason about these religious practices, and we as judges can decide that the rationale for it was whatever they thought it was, and today that rationale no longer exists, right? And that is exactly the kind of reasoning that Biju Emmanuel warns judges against, right? It's not about whether you agree with the rationale, it's not about what you think the rationale is, it's not about whether you consider it a good practice or not. So yeah, to me it's kind of there's just no winning, there's just no way they could have won on this approach to religious practice.
It's quite irrelevant. The temporality of it is completely irrelevant, is it not?
Well, the problem is that once you go into ERP, then by judicial fiat over the last 70 years, it is the only thing you have to look at is how old is it, and the older it is, the greater claim that you have. Which I think, as I said, the problem is then it basically there is this fantastic article I keep recommending. It's called "Cultural Descent" by Madhavi Sundar, where she really shows how, like, religion and culture, basically people are always in negotiation with what their own dominant culture requires, and they're always trying to kind of reinterpret it in a way that their freedom can increase, specifically obviously women. And so when you say that, like, because this wasn't there in the Quran, therefore you can't do it now, you're basically telling the women that you are not permitted. And this is not just about Islam. I think this is true for all the cases in ERP. You're telling the people who want to actually challenge dominant interpretations, who want to actually craft their own relationship with their religion. You're telling them you can't do that because this is what your religion actually says.
Exactly.
And you have no scope to reinterpret that in a way that you actually want to. But yeah, so on the indirect discrimination, so I think again that the 2 points here, right? I think one is that one is the GO itself. I think is the text of it. I still think is not directly discriminatory because it is still facially like neutral. So I think for me it's a hard sell to say it discriminates directly. But I think on the equivalency side, I think there is another part of the judgment that I disagree with on the public order bit, right? So the term used is this in the Kannada version is the same as used in the Constitution, public order. So there, of course, then you have issues around the heckler's veto because public order cannot be a ground if some people are doing something and then in response somebody does something, then you obviously can't ban both of them saying public order, right? You have to look at the chronology, so to say. And then the court's answer is that actually no, you can't attribute the same meaning to the words because government drafts people don't know what they're talking about, they're incompetent, and therefore, I mean, for me, this was the most surprising part of the judgment because one thing that you kind of always go with is that if the text is clear, right, clear in the context of the interpretive community you belong to, obviously, then there is no further scope for intent, for all of that, right? So if the text is clear, then the inquiry ends there. This is what they mean. So if they say public order, then they mean public order. Whereas now, in this case, what the court is saying is that actually, because they're so bad with drafting, even when they're clear, we take them as not being clear because they didn't know what they were talking about, which I think is very surprising. I mean, I found that quite surprising. I really couldn't understand. I mean, I think for the rest of the judgment, I can agree, disagree, but I get the argument of the court. Here, I just didn't get what was happening because it just seemed bizarre that you're saying that the words are clear, but the draftsperson is incompetent. Therefore, we're going to not take the words as clear, which is, yeah.
But you're still doing exactly what the draftsperson intended for you to do. You're barring both things because you're saying that it's contributing to public disorder. So the operative part of the judgment, the
I
interim
think that
one,
didn't really come across, right? Like it was more that we're not taking these words as meaning public order because
but we are still barring it because it's
yeah.
causing, But again, Gautam, going back to the geo, what else do you think it bars except the hijab?
So I think that it would. So this is the thing. I actually think, and this is obviously So I think if you actually would take that geo on its face, it pretty much bars all visible headgear. It follows that it actually then bars the turban. I mean, like it follows, and of course now when the argument is going to be that the turban is essential. It's essential, and therefore it's exempted from the terms of the geo. And yeah, but I think that
Doesn't the judgment clarifies and says that this only, so therefore no hijab, no this, no that, no bhagwa.
So
It doesn't
before
mention the term. Sorry, Farah. Yeah.
So before we get into the judgment, I mean, just going back to the terms of the GO, Gautam, I suppose I see your point, but I guess to me, what is really significant is the line in the GO where they say some people are following their religious practices and this is causing problems for equality or something to that effect, right? So even if we were to say, okay, this is not targeting headscarves, not targeting the hijab, is not targeting Muslim women. If we were to say this is targeting everyone who covers their hair or head for religious reasons, that to me is still direct discrimination because you are targeting people based on a protected characteristic that is religion, right? So to me, yeah, I think that is the argument for direct discrimination.
right, okay.
Yeah. So can I just come in as well on the saffron scarf question that Shahrukh raised, because I'm interested to hear if people have other views, but I've heard a lot of discussion about the to the effect of, they're drawing an equivalence between headscarves or the hijab worn for religious reason and the saffron scarves, right? Or the saffron flags or whatever, right? And the idea being there's something offensive about the fact that both were banned. One should have been protected, one should have been banned, right? And I'm not sure that it's that simple at all, actually. I think it's right to say they are not equivalent, and you are really, it's a kind of reductive argument to say this is the same sort of thing and we treat them exactly the same. But I'm not really convinced that the saffron scarves or that kind of dress or that kind of accessory should not be protected as well, because to my mind, I mean, we have to think a little more about what it signifies and what it means. But if it is, for instance, a political statement, I think the protection of political speech is really, really important, right? If it's the protection of some really just going back to what Gautam said, that religious identities and cultural identities are developed in conversation, in contestation with others. So if this developed as a part of the conversation, the part of the contestation with the headscarf, then it follows from that this is actually, we could say, a kind of religious expression as well. So to me, it's not so simple that, I mean, and I'm not saying either of you suggested this, but I've heard more generally people kind of questioning, or people very uncomfortable with the idea that the saffron scarf should be protected, whereas I actually think it's probably good reason to protect the saffron scarves, except if we think that it is a kind of hate speech, to, like, like you have the burning cross as an expression of hatred of black people in the US, for instance, right? And I think, yeah, I mean, you have to say much more to make that case. Just on the face of it, I'm sympathetic to the protection of the saffron scarf.
Mm,
I kind of completely agree. I mean, I think that the saffron scarf is on the exact same terms, should not be banned. I'm thinking about this famous case again from the ECHR, which involved the hammer and sickle, right? Like in was it Belgrade. I can't remember the exact place, but basically, I mean, basically, the question they banned the hammer and sickle post-communist times, and the argument was that actually the hammer and sickle is a Soviet symbol, and it's therefore the symbol of authoritarianism and so on. And the court actually said, look, first of all, it's not that simple. It can have at least one of two meanings. One meaning is Soviet tyranny, authoritarianism, and the second meaning is workers' rights. Now, unless you show comprehensively and dispositively that the only meaning it can carry is this authoritarian meaning, then yes, you can ban it, but you haven't really shown that. And as long as it's
mm,
capable of
mm,
carrying more than one meaning, you can't actually ban it. So I think in that sense, it's for me, like, it's obviously, as I say, you should actually allow the hijab and the saffron scarf, and range of other religious identitarian markers. And as I've said before, I think it's
mm.
actually improves the overall kind of stylish
Plurality,
and
yeah,
aesthetic
yeah.
diversity, right? Um,
And
and of course,
genderless clothing, yeah.
is that sorry.
No, I said and genderless clothing, which
Yeah,
will
no,
come up.
exactly. So the NALSA case specifically talks about
Yeah,
clothing
yeah,
as a form of
yeah,
expression. But of course, I mean, I think again the issue, of course, is that in all these cases you have to test the reasonable accommodation claims on a case by case basis. I think one thing that is there in the judgment, and I think one thing is that I have heard in discussion, is this basically slippery slope kind of an argument, a parade of horribles, right? That today hijab, saffron headscarf, and XYZ. Tomorrow burqa, niqab, like jilbab, no clothing at all, like all kinds of things, right? Uh, I think again that's just like a lazy argument, right? Because as I said, as the court's own distinction between the nose stud and the hijab, which I disagree
yeah,
with, but as it
yeah.
shows, you can actually draw lines, and the court's job is to draw those lines.
Mm,
So I think it's perfectly okay to say hijab and saffron scarf allowed, and like niqab or something of that kind not allowed. And you can actually have good reasons, as the English Dendic case actually shows.
mm. I'm dying to make 2 points, and then I'll shut up. I think we're also approaching our 1 hour. One, the first point was something that Gautam had referenced earlier on, which is the focus of the court on discipline as an aim in itself, as cogent ground. And at some point, the court also says that nobody's showed us anything that suggests that discipline is not a good thing. I don't know why nobody showed them Foucault, nobody showed them Agamben, but I want to make a larger point about discipline or even uniforms constituting the subject citizen. So I went to a Catholic school, a missionary school, many years ago in the 80s, and we had uniforms, and we were also not expected to ask questions in class of our teachers because discipline. It was considered very bad form to ask questions, and we're able to now laugh about it. But they were constituting convent-educated brides. That was our role, to sort of listen to what is being said, etc. And similarly, just today, I saw this very interesting piece of news about Tokyo schools, where there was a rule apparently that everyone had to have black hair. And if your hair was brown, you were to dye your hair and then go to school. And I think that had something to do with the perception of the Japanese national trait as having black hair. You're not supposed to deviate. You're not. If you have that, you're an aberration. Farah was saying that and by disciplining, by prescribing uniforms, you correct those aberrations. You bring everyone into line. So for me, what this judgment does by endorsing the importance of discipline and uniform, and then also endorsing the fact that certain visible markers violate freedom and dignity, is to constitute citizens which would recognize certain markers as being extreme or as being outsiders, as needing correction. And you see that all around you. You see that in the vigilantism that is all around us, where they're correcting aberrations, they're correcting bad behavior. So that was one. And the second point, which is really a question for both of you, how do you interpret explanation one of Article 25, which explicitly says that the carrying of the kirpan is part of Article 25? So why not refer to the more obvious pagri? Why the kirpan? And is it because that pagri as just a garment, it was a given that it obviously it's acceptable? What's to say about it? You only make a point if it's the kirpan, which is more than a garment, which is actually a weapon, or it could be a weapon. So that was one time and space where innocuous pieces of garment were not a problem. In fact, you allowed space for kirpans also. And then does this particular judgment collapse that space when it explicitly compares uh, the hijab with a firearm during the oral hearing?
Yeah, so I mean, look, I think you're spot on in your analysis of that explanation and what the judgment does. I think to respond to your first point, Shahrukh, about the disciplining, I think a lot of people have commented on the analogy and the judgment between prisons and war rooms and schools, right? And so I just really need to say that as an educator in particular, you really wonder what vision of education is at play there, because I think as an educator, the last kind of environment you want, and this is not just personal preference, this is, we have social science that backs this up, right? If we want any sort of if that diversity is good for cognitive reasoning, that diversity is good for learning, that in order to learn you have to have learning happens within relationships, it happens within relationships of caring. It does not happen in a martial type environment, and again, there's clear social science that backs that up. So as an educator, putting aside my status as a lawyer or legal scholar, as an educator, that line is so troubling. I just want to mention two other features of the judgment, and I know we don't have time to get into it in lots of detail, but I think maybe at this point we can just say the couple of things that we thought are really important that we haven't been able to get to. One, as I mentioned before, the court's approach to arbitrariness. Now, obviously, the arbitrariness doctrine, manifest arbitrariness, it's been heavily criticized. I get that, but I think it is wrong, and it is, wrong in law and wrong more broadly to conflate it with discrimination, because I think it is actually aimed at a different kind of problem, and it is aimed at a problem where you have a government official, you have an administrator who is not making mistakes, not just reasoning incorrectly, but is indifferent to reason and is acting on pretext, basically, right? So these are that kind of indifference to what actually should the reasons be that underlie a decision, this indifference to whether what you're doing is supported by reason. This to me is at the heart of arbitrariness, and that I think should be the test for arbitrariness in this jurisprudence. And I think if you read the cases, that is what it says. Yeah. And just the final really important part of the judgment, I think, is this discussion of qualified public place and this suggestion that there's a difference between derivative and core rights. We can't get into it, but I just think both very, very troubling jurisprudential suggestions.
Yeah, I think
if
my
anything
final
at all,
point is
sorry, Gautam, sorry. I was just saying that if anything at all, the campus or the school should be a freer democratic space than a qualified public place. But sorry, Gautam, go on.
Yeah, no, I mean, my last point is that, which is the operative part of the judgment, is that the application of it is limited to classrooms, and so I think that it's just important to remember that, because there's always a gap between what a judgment actually says and what its perception then becomes in like the public sphere and what it's used for. So I think that it's just important to emphasize that ultimately, whatever our agreements or disagreements with the reasoning in the judgment, it is specifically in the context
Mm.
of the physical kind of classroom space, and its impact is limited. Legal impact is limited to that classroom space, and not beyond that. So I think it's important to remember, like going forward, what the propositions in the judgment stand for and what they don't stand for. So yeah.
So
Although it
not even
uses,
out. Sorry, yeah.
yeah. No, and I
I
was
was
saying that it uses schools and pre-universities quite interchangeably, though, throughout the judgment. It sort of forgets that we're talking about adults slash young adults, people in their who's 17, 18, 19, basically. But you're right, the operative part still restricts it to the classroom.
Yeah, it's
Although
like
the
the
body of the
space of the
judgment is,
classroom. It doesn't even say
yeah,
the school
yeah,
premises. It says
yeah,
classroom. So I
yeah,
think that that's just it's just worth just like remembering that legally that's what the judgment says.
yeah, yeah. Farah, you were saying something.
Oh, I just wanted to underscore that point that Gautam made, and in fact, I think the judgment itself draws that contrast: classroom as opposed to school premises, right? So it is, even though we might think there's no principled ground to make that distinction, the judgment does make that distinction. So what we're seeing on the ground in terms of people being forced to disrobe at the gates or even inside the school grounds, that is not contemplated by the operative part of the order read with the judgment, as Gautam said.
And it also rejects the proposition that there should be an inquiry into the overt politicization of people, as in they're wearing hijabs because they're being politicized. And someone wanted an inquiry into it. And I think the court rejects that proposition quite categorically.
Yeah, it was a sealed cover and like all kinds of things.
Yeah,
And it's
yeah,
just
yeah,
count our blessings that is enough dispensed with in the judgment, and there's nothing further there. Yeah.
right. Well, this was fun. Thank you.
Thank you.
Thank
Thanks
you
so
both.
much, R.
Thank
It's
you.
lovely to talk
Bye.
to you. Bye.
Bye. Bye. Bye, Gautam. Bye, Farah.